That's absolutely correct, and I think we're on the same page in this. Proceeding under 28C, the Supreme Court has 7 options available to it. And actually, it's a little bit misleading because option 7 is make such or further orders as the court deems appropriate. So there are a number of options. But there are 6 options articulated in the rules on lawyers' professional responsibility under Rule 28C. So there's an assertion of a disability in a disciplinary proceeding. The referee makes a recommendation to the court that, in fact, respondent is disabled. The very first option under 28C, which is the one I mentioned earlier, was a transfer of the lawyer to disability and active status. All right, that's the first recommendation. Next, option 4, stay the disciplinary proceedings, and there's also language because this would apply in the case of a conditional admission, but that's not relevant for us. Stay the proceeding until it appears the lawyer can assist in the defense. So the referee is saying, all right, first, she goes in disability and active status. Second, we stop these disciplinary proceedings. It doesn't make sense to force an attorney to participate in a disciplinary proceeding when the lawyer is disabled and not able to competently participate in that proceeding. I presume that's the reasoning for 28C in the first place. And then finally, option 6, appoint a referee with directions to make findings and recommendations to the court regarding the disability allegation or to proceed under Rule 14. And what I'm suggesting is, and that's an option as well, but what I'm suggesting, the process, the proper procedure for having that proceeding would be a petition, because respondent's in disability and active status. Let's assume that. She's not able to practice. Right. Now, to be able to resume the practice again, a lawyer goes through a process under Rule 18 of the Rules on Lawyers' Professional Responsibility to petition to be reinstated. And then in that process, there's a hearing, evidence of disability or the absence of a disability now, and the fitness to practice is all developed as part of the record. And then if the panel recommends reinstatement, then the lawyer is reinstated to the practice of law. And at that point, the disciplinary proceeding could continue.
Counsel, let me follow up, because what I'm finding important here is getting the sequence of events, but what it is that we conclude from the record or we find is sufficient to show that there's reason to place the attorney on disability inactive status. But see, that will be the template. I mean, we got to look down the road to the attorney being able to be restored to active status. And if we aren't clear as to the grounds or the basis to place on disability inactive status, I'm a little concerned it could be a little mushy, a little imprecise for the attorney when the attorney wants to or is in a position to petition for reinstatement. So that's why I think it's important it's clear as to what is the threshold, what is the necessary, what is the evidence that's sufficient so that, it's a continuation of the process.
Well, Your Honor, the evidence that would have to be shown and the burden would be the same as in any petition to be reinstated to the practice of law. The lawyer would carry, the petitioning lawyer, I'll switch from respondent to petitioner because at that point the lawyer becomes the petitioner. The petitioner would have the burden of showing by clear and convincing evidence that he or she is fit to practice law. That, and there's case on that and a number of cases where lawyers have been readmitted to the practice of law after disability, after discipline, for various reasons. There's a showing of a fitness to practice law. That would be the same standard that would be imposed here.
But here's my point. If I'm petitioning for reinstatement, that I am fit to practice law, it would be very helpful for me going forward to have as precise of information as to what was the basis for the finding that I wasn't fit. See where I'm going? Is that, you could respond, and you could respond vaguely if the grounds for placing on disability is vague. Mm-hmm. And so that's where I want to be as precise as possible as to what's necessary going forward and what is the basis we can use.
Well, and that would be developed as part of the investigation that the Director's Office would conduct. There would be a request for medical records. We would suggest an independent medical examination upon reinstatement, and we would more fully explore what was the basis for the asserted disability? Why was the respondent lawyer not able to participate in the disciplinary proceeding? And having developed that record, has that issue or has that condition now been addressed? If it has been addressed, then the lawyer is able to proceed, be reinstated, and the disciplinary process proceeds. If the lawyer is not able to make that showing, then the lawyer remains on disability inactive status until that showing can be made. And, Your Honor, I would suggest it might be a little bit different, but in some cases where a lawyer's been suspended and they haven't asserted a disability, but they have to go through a Rule 18 proceeding, we grapple with that same issue at that point. Well, if they had claimed alcoholism and they can show, well, now they're no longer an alcoholic, that makes the showing easier. I will grant you that. But there are certainly cases where lawyers are disciplined for more amorphous moral failings, if you will. And that gets a little more difficult to get your arms around, but we have experience with that. We have done that. There have been proceedings, and lawyers have been recommended for reinstatement, and the court has reinstated those attorneys after those proceedings. If I may, I would maybe abandon my prepared argument a little bit, but to address your concerns about the process and what are some ways we can go about this, because this is a unique situation, and it does raise some concerns in the director's offices, and I've given this a lot of thought about, well, how do we proceed and what are some options? The concern with, and I'm not sure if this is something the court's looking at, the concern with simply keeping respondent on active status and then referring it for some type of disability hearing raises a real question with burden of proof and timing of the process, and also protection of the public. So, for example, say the court refers this back, and normally the director has the burden of proving these things. Well, the director is then in the somewhat illogical position of having to prove respondent's assertion that she's disabled. And, you know, obviously that would be difficult and not impossible to do, and not the way the process normally works. The court has established a process. For disciplinary proceedings, the director carries the burden, and the director has to show the unprofessional conduct by clear and convincing evidence. But in cases where the lawyer's ability to practice law has come into question and the lawyer is seeking to be readmitted, then the lawyer carries the burden, which makes sense because the lawyer has access to the information showing that he or she is or is no longer, presumably no longer since they're bringing the petition, no longer disabled. There's also a question with timing with that thing. If again, if it's just referred back and the lawyer remains in active status, what happens if the director, you know, sets a date, contacts the referee with the respondent, we pick a date, and we're all prepared to move forward with the hearing on the disability, and the respondent lawyer says, which has happened here, I can't participate in that. I've had a relapse, my condition is aggravated, I'm not able to participate. Well, the lawyer remains on active status. There remains a concern about the lawyer's ability or disability. The lawyer has just asserted it again, yet there's really no way to proceed forward. Does the director then initiate an action in the absence of the respondent lawyer? The director doesn't think that's advisable, and the referee specifically rejected that option in considering this thing. The referee said, and you'll note in there the director's office agreed, that the respondent needs to be there, needs to be participating in that proceeding, and if the respondent can't do that, then the proceeding shouldn't move forward. Third, the concern the director has is of risk of harm to the public. As the referee found, a number of the issues that were raised by respondent's counsel in the Wednesday afternoon submission, which was actually, I think, intended to be a submission that showed that respondent was okay now as of Wednesday afternoon and could proceed, although respondent's latest brief indicates that wasn't accurate. In fact, there were subsequent problems. But the issues that were identified in that medical report all dealt with issues that affected the ability to represent clients. And the referee expressed the concern and recognized, as the director does, and as I presume the court does, that this is not something we undertake lightly, and there is great concern in placing a respondent lawyer on disability and active status. But we have a risk of harm to the public where a lawyer is not able to properly practice, not able to look out for the interests of clients, and proceeds to practice, and we can't move forward with a disciplinary proceeding because the lawyer asserts that she's disabled.